This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
In this chapter, we look at the implications of different business structures. Now, the common business structures, and you probably know this, are sole traders. This is really a person starting on their own and trading on their own. They're the only owner of the business. They could have employees, but there's a single owner and a single person who receives the profits from the business. You can have partnerships, which is where you have two or more people working together with a view to making profit. They will each put in capital to the business, they will each work in the business, and they will be entitled to a share of the profits, an equal share or some share which has been predetermined by some partnership agreement. And then we have limited companies or incorporated entities. Now, limited companies or incorporated entities are known as, or can be described as, legal persons or persona at law. They have a separate legal existence, just as you and I have separate legal existence. And that legal existence is distinct, separate, independent from their owners. So limited companies can own property in their own name. It can be the name of the company which is on the land registry documentation saying this company owns that property. The company can have its own bank account and so on. The company will be liable for its own debts. It's not the liability of the owners of the company, the shareholders of the company, to pay the company's debts. These are the company's liabilities, and that be paid by the company assets, the cash. Or the company will sell its own inventory which it owns to get the cash to pay the liabilities. Companies can sue and be sued in their own names. So if a company, if its customer doesn't pay the amount due, then the company can go to court, and of course it will be the directors which initiate, if you like, or act on behalf of the company, but it is a company which is suing the debtor. Or if it's the other way around, if the company sells something and these products it sells are below standard, and there's a legal case to try to recover damages for the inferior quality, then the company will be sued in its own name. It's also, as well as civil liabilities, it's also possible for a company to face criminal liabilities. Of course, a company can't be sent to jail, but a company can be fined. And there are many cases of companies being fined very substantial amounts for breaking rules and regulations and laws. Or maybe if an employee has been injured or killed, not only will the company have to pay compensation, but the company will have to pay a liability that arises from some sort of a criminal negligence or breaking some sort of law, and that's its punishment. And then companies pay their own tax. With sole traders and partnerships, the profit of a sole trader becomes the income of the sole trader. The profit of the sole trading business becomes the income of the sole trader, and that sole trader is going to be taxed through income tax. In companies, the income of the company is separate, and that is going to be taxed through corporation tax, and the company has to pay the corporation tax itself. If dividends are paid to the shareholders, then those dividends become income for the shareholders, but those dividends have been paid after the corporation tax has been paid by the company. Potential advantages of forming a limited company. Well, taxation. From time to time, the tax of a limited company, the tax rate, is lower than it would be if the profits were earned by a partnership or a sole trader. Limited liability. Now, what you have to understand here is when we talk about limited liability companies, is the limited liability here is for the shareholders. not the company. So the company goes into liquidation and creditors are owed money by the company. Then the creditors can claim everything the company owns. It has got unlimited liability. But then, in general, the creditors cannot pursue the shareholders. The shareholders' liability is what's limited, not the company's liability. Succession of the business. If a sole trader dies or a partner dies, then in many circumstances that business ends. And there can be tax implications of stopping and starting the business again or whatever's going on. The limited companies can be essentially eternal. The owners of the shares can change, but the company goes on until the owners decide to put that company into liquidation, to wind it up. It also means that there's easy transfers of units of ownership of the company. So if a company has got 10,000 shares in issues, then potentially there could be 10,000 owners, each of one share each. And the shares are a very easy way of keeping record of who owns the company, who's got certain votes in the company, what dividends people get in the company, because it's all proportional to the shares they own. Some people think that a limited company gives an air of being professional, of being a business of some substance. If you see a business simply called J. Smith and you realize it's a sole trader, you begin to think it's a very small business. But if you see something like J. Smith Limited, then people think, well, maybe this is more substance. Of course, it needn't be. This is almost a marketing ploy. And raising finance. In particular, limited companies, if they grow big enough and they have got the right sort of a trading record, they can become listed. Meaning they can go to the stock exchange, they can issue shares to the public, and that opens them up to a vast source of capital, which they can use for expansion. Sole traders can't really operate like that. Partnerships find it quite hard to operate like that. They don't have the same host of people who might be willing to invest onto the stock exchange, because the great thing about the stock exchange with a listed company is it's very easy to buy and sell the shares. So I could invest, $10,000 this year, keep it there for a few years, and then very easily sell those shares again, because there's a ready market once the company is listed. And this makes it more attractive for me to invest in a listed company than maybe to invest in a partnership or a sole trader, because there's a problem, how do I get my money out again? Disadvantages? The disadvantages, there are certain formalities in establishing a listed company. You go through a process, what's called registration. It's actually not too bad. The way most people acquire or start a limited company is you can buy limited companies, what's called off the shelf. They are already set up, and then you can buy it, you can change its name, you can put yourself in as a director, you can pay some money into the limited company, and the whole thing can be really done within a day. But then the other main formality about limited companies is that they have to annually file accounts with Companies House, and once they get to a certain size, they have to have what's called an audit. And we've talked about audits. They have to have auditors who inspect the accuracy of the financial statements. And this takes money. This costs money. And it also means that these formalities of having to file your accounts with a Companies House means that there's going to be publicity. So publicity means that everyone can see your profits. Whereas if you're a partnership or a sole trader, of course the tax inspector sees your profits, the tax authority sees your profits, but members of the public have no particular right to see what your profits were. And I've put here on the other side, we've got kind of tax on both sides here. I think you could argue there's a certain tax kind of disadvantage simply because you have to do your corporation tax calculations, And then you have to do your personal tax calculations, because these are two different entities. Whereas if you're just a sole trader, there's just the one tax computation. So again, this could be adding slightly to the administrative expenses. A company has got two main constitutional documents. The first is the Memorandum of Association, and this, if you like, really sets the basis of the company. This can be done really on a couple of pages here. It'll have the company's name. It will say when it was incorporated. It's incorporated always with a number, corporation number, company number. It'll say the type of company, and most companies are limited by shares. You can have companies limited by guarantee, but they're relatively rare. It'll say the piece of law, the piece of statute used to incorporate and to form the company. It'll have the names and addresses of the subscribers, and the subscribers are simply the people who kick it off, really. They are the original shareholders who almost are there at the birth of the company. Very often, with one of these off-the-shelf companies, the subscribers will be a lawyer maybe, and then as soon as you buy it, if you like, you buy the shares from the lawyer, you are replaced as the shareholders. And it will say the limited liability. It'll have this, the limited liability of the shareholders. It will say that these shareholders' liability is limited. Just a very formal statement establishing limited liability. The Articles of Association are more to do with the day-to-day running and administration of the company. So it will say things like what directors' powers are, how they are to be appointed, how they can be removed. It maybe say something about how the directors are to be remunerated and so on. It will talk about the types of share, how many shares there are. So it could be 1,000 shares of $1 each, could be 10,000 shares of 50 cents each, and so on. It'll define these. It'll say how they are to be transferred. In some smaller companies, these rules would say that if you want to sell your shares, you have to offer them first to existing shareholders. So it kind of keeps the ownership of the company, if you like, amongst friends almost. Once a company becomes large, and when it becomes a listed company, then you can't do that. You can't have these what's called preemption rights. It'll talk about the rights of dividends, because you can have different classes of shares. And different classes of shares, ordinary shares, preference shares, ordinary A shares, they've got different rights to dividends, different rights to voting and so on, to govern the company. Power to capitalize profits. So you earn some profits. What you could decide to do is to turn those into shares and issue more shares to people. So rather than paying them dividends, you simply change the nature of the capital and you say you now own shares. Decision making by shareholders. Who is entitled to attend meetings? Who can speak at them? Who gets what votes and so on? What do we do about proxy votes? A proxy vote is what happens if somebody can't attend the AGM. Can they fill in a form and say, I want that person to vote for me? I'll leave it up to that person, or I want this person to vote yes on this resolution and no on that resolution. All of this has to be set out so that people know their rights and their obligations. And then administrative matters, what sort of communications should be used. Is it okay to distribute the annual report by email, to have it available on the internet? Or is it a company where everyone is entitled to get a paper copy of the annual report? Are directors insured? What happens if directors do something inadvertently, which means the company does something illegally, and the company is sued? Can the company then go and pursue the director for the illegal activities which the director happened to cause the company to partake in? So this is very much to do with, let's say, almost the inside of the company, the day-to-day administration, the day-to-day governing of the company, to make sure everyone knows their rights and obligations and how things should be properly done. There are two sorts of companies. There's a private company and a public company. A private company in the UK is designated by LTD, meaning limited, after its name. It cannot offer shares to the public at large. It can, of course, transfer shares. It can approach individuals, but it cannot offer shares in general to the public. There is no minimum capital requirement, and many small companies start off with $2 worth of share capital. And it may have only one director. It can have more directors, but it is allowed to just have one director and in a way, $1 of share capital. Very, very small. But the great thing is it gives that director owner, who otherwise would have been a sole trader, it gives this person limited liability. If the company does something wrong, if somebody gets injured, maybe by a product the company is making, then the liability of the director and owner is limited in most cases. A public company is designated in the UK by having PLC after its name. This means Public Limited Company. The great thing about a public limited company is it can offer shares to the public. But beware, just because something is a public company does not mean that it's a listed company, okay? Those are not the same. If you want to go on the stock exchange, you have to be public, but if you're a public company, you do not have to list on the stock exchange. You might be waiting for 10 years before you say, now's the time I need to go and raise more finance. There are minimum capital requirements, and you have to at least 2 directors. So these are aimed at bigger companies, more substantial companies, and an awful lot of them do eventually become listed on a stock exchange. And the final topic we have to look at is what's known as the veil of incorporation. And what the veil of incorporation means is there is a distinction between the company and its owners. So we have the company and we're the owners. I've already seen this in terms of limited liability. We know that the liability of the company is unlimited, but the liability of the owners is limited. So there's a distinction, a division, if you like, between those. And there are a couple of cases in your notes just emphasizing this important concept of the veil of incorporation. One is the famous case of Solomon and Solomon, where Mr. Solomon was both a director and a lender to the company, and his loan was secured. In other words, it was attached to property of the company, so that if the company failed, this mortgage as it was, Mr. Solomon could, if you like, grab the property of the company and sell it and reimburse himself out of the proceeds. And the company went into liquidation, and the other creditors, there was nothing left for them, because Mr. Solomon, who remember was the shareholder, but was also a creditor, grabbed the assets of the company and reimbursed himself as a creditor out of those. And the other creditors, the other lenders to the company, complained and said, look, there's really no difference between Mr. Solomon as a shareholder and Mr. Solomon as a lender. It's essentially one and the same person. And the court said, no, they are different. They are legally different. Mr. Solomon has one existence, if you like, as a shareholder, and is an entirely separate existence as a lender to the company. And these are distinct roles. Another case which you have here, and which is why we have this picture of a forest fire here, is a case of Macquarie. And Macquarie owned a company which owned a forest, basically. And there was a risk of forest fire, and Mr. Macquarie insured the timber, insured the trees. But he insured the trees in his own name. And he was planning that if there was a forest fire and it burnt down, then he would be compensated. However, to have valid insurance, you have to have what's called an insurable interest. There has to be even it has to be you losing the property. You can't insure somebody else's car. You can insure your own car, but you can't insure somebody else's car because it's not your loss. And here the forest did burn down, and Mr. Makara claimed under his fire insurance, and the insurance company refused. It said, "You are Makara, you do not own the forest. You insured the forest, you insured the wood, and it is the company which owned the wood. It is the company which has lost the wood. You might have lost value in the company shares, but you have not lost the wood. Therefore, you had no insurable interest in the timber itself, and the claim was turned down." So this very important distinction between the owners and the company. Now this so-called veil of incorporation can be lifted, or sometimes it's said the veil can be pierced in certain circumstances, really where incorporation is used to protect the shareholders, really, against improper behaviour. So there's one case, Gifford Motors, in your notes, where there was an employee who had signed a contract with his employer not to compete. And he left, and he set up and he was in the motor business, and he left and he set up a company which was in the motor business and which was competing with his old employer. And the old employer objected to this. And what the ex-employee said, he said, "It's not me competing, it's my company who's competing. Okay, I had a contract with you not to compete, but I'm not competing, it's my company." And the law said, look, you're just using incorporation as a front. It's really you who is competing, and you're trying to kind of get use out of this veil of incorporation for improper behaviour. The other reason that the veil might be lifted is really looking at limited liability. If the directors know that there is no realistic prospect of a company surviving, yet the directors go on and keep buying material, knowing that those suppliers will never ever be paid, then those directors can be held to be liable. We're not talking here about a company just failing. I mean, one of the reasons for limited liability is to encourage people to trade, to take a bit of the risk out of it. We're talking here of directors deliberately, really, causing the company to always defraud the creditors. Then the creditors can say the directors were really acting improperly, and in those situations and those types of fraudulent transactions, really, the creditors can pursue the directors personally.